Good afternoon, everyone. We have two cases on the afternoon call. They're both full grants, but both are 20 minutes of argument per side. We will call the first case, People versus Masalmani.
Good afternoon, Your Honors. Erin Van Campen of the State Appellate Defender Office, appearing today on behalf of Ihab Masalmani. With me is my co-counsel, Tina Olson, and if I do have any time remaining at the end of this argument, I reserve that for rebuttal. This court should issue an opinion clarifying that when the government seeks a sentence of life without the possibility of parole for a juvenile, the government bears the burden of supporting that request. This is clear from MCL 769.25 and 25A, which both designate the government as the moving party. The statutory language is dispositive in Michigan, and that's because our jurisprudence establishes that the moving party bears the burden of supporting its requests. And our principles of statutory instruction require us to presume that the legislature is familiar with and legislates in harmony with Michigan's existing law. That the government must bear the burden is also consistent with juveniles' constitutional rights to due process and to be free from cruel and unusual punishment. Our position in this case is consistent with this court's recent decision in Skinner. In Skinner, this court recognized as a matter of constitutional law that a judge cannot sentence a juvenile who is not irreparably corrupt to life without the possibility of parole. An opinion from this court clarifying that the burden rests with the government will help ensure that sentencing courts do not violate the Eighth Amendment rights of juveniles. Finally, this court should clarify that a sentencing court reversibly errs and abuses its discretion under Miller when it relies on a Miller factor as an aggravator, when it disregards a Miller factor altogether, or when it fails to tailor the sentence to the individual before it. Here, this court made all three of those errors, and that is why we ask this court to vacate and remand.
Counsel, what do we do with the fact that Skinner says there is no presumption one way or the other? How do we harmonize that? That's the law of our state now. How do we harmonize that with the statute and Miller and Montgomery?
It's not difficult, Your Honor. The concept of a presumption is a distinct legal concept from a burden. They're not one and the same, and it's not the case that just because there is no presumption, that means there is no burden. A presumption is, an inference we must draw from a particular set of facts, whereas a burden is a party's duty to show that their arguments have merit. So I think the analysis of the presumption argument is different in kind from the analysis of who bears that burden. The other thing about the Skinner decision that I think is very clear, Skinner speaks to what the trial court needs to do in its analysis. It speaks to the fact that there are no magic words that a trial court must recite before it can impose a sentence of life without parole. But it is also just as clear about what the court has to do with those Miller factors, and that's to apply them for their mitigating effect. And so the position that we have put forward in our briefs and in argument today is consistent with this court's decision in Skinner. It's still the case that there are no magic words, but that leaves trial courts without a whole lot of guidance between there are no magic words, but also I can't impose this sentence on someone who's not irreparably corrupt. Skinner does say that. And so it is critical for a lot of the reasons laid out in the brief filed by the criminal defense attorneys of Michigan, that trial courts desperately need this guidance, because without this guidance, and in a world sort of envisioned by the prosecution in Pam where there is no burden, there are no findings, the Miller hearing becomes a black box, and the Miller decision becomes one about which a trial court has virtually unfettered discretion.
Possibly there are elements of Skinner that are more troublesome, more of a burden, in particular language to the effect that the statute does not require anything to be proved. Rather, it only requires consideration of relevant criteria. If nothing has to be proved, why is it necessary to identify a burden of proof?
Well, it is still necessary. I mean, I think there are different questions at play. So what this court found in Skinner, as I understand it, is that the court doesn't have to find irreparable corruption. That's a legal term of art. It's not the sort of fact kind of thing that courts are in the habit of finding. But a sentencing isn't done in a vacuum, and a Miller decision isn't done in a vacuum. These hearings involve contested facts. They involve expert opinions. And when courts are laying out their reasons for choosing the sentence they have as the statute requires, those kinds of considerations are sort of always at play. I think of it being akin to in an ordinary sentencing context under the guidelines. The ultimate sentence imposed is within the discretion of the sentencing court. However, there are a number of places where the government bears a burden. When the defendant challenges facts in the pre-sentence report and says they're inaccurate, the government bears the burden of showing that those facts are accurate. When there's a challenge to a restitution amount, the government also bears the burden of showing that amount that they are seeking is supported. So I think it's a misstatement, not necessarily an intentional one, but a misstatement of the law to say, as the prosecution has in its briefing, that there is no burden in Michigan sentencing at all. And so we want to ensure that these juveniles don't end up in a position where they have less meaningful appellate review and less meaningful review at sentencing under this sort of notion that there simply is no burden. I think if there are not any further questions at this time, I will reserve the remainder of my time for rebuttal.
Any other questions, anyone? Okay, thank you.
Good afternoon, Your Honor. May it please the court. My name is Joshua Van Laan. I'm an assistant prosecutor in Macomb County, and I'm appearing today on behalf of the appellee, the people of the state of Michigan. I think initially, just to, cover the issue of whether or not there is a burden. You could either say it as there is no burden, as we have in the brief, and it's on the court to be presented with the information to consider and to make the decision, or you could say it as we both have a burden of production of known mitigating factors. If we have information that we know to be a mitigating factor, we should produce it. The state doesn't withhold things. Just like if the defense has information about a mitigating circumstance, they should produce it. But as far as who has the burden of persuasion as to whether or not life without parole should be imposed or should not be imposed, that is where we do not have a burden, and neither does the defense. The burden of producing the information is what Miller calls for, and is consistent with what Skinner and Montgomery, which really didn't discuss this issue too much, but there is no other case, there are no cases that talk about whether one person or one party has to prove life without parole is required or not required. Rather, the court needs to be presented with the information, and both parties, like in any case, are responsible for that. But as far as the court's question of who has the burden of proof as to whether or not life without parole should be imposed or should not be, neither party. And frankly, that's just because the case law hasn't established it. With regard to the comment about whether the prosecution files the motion, the statute, MCL 769.25, requires the prosecution to file the motion if it intends to impose the life without parole sentence for the procedural purpose of knowing what needs to be addressed by the court, what the parties are seeking. It's not because we bear the burden of proving life without parole is required. We certainly have an argument, are permitted to make an argument that based on the evidence presented, the Miller factors as well, do not mitigate any of the evidence presented or the institutional conduct of the defendant, and therefore life without parole is appropriate. But that doesn't necessarily require it to be our burden.
If there's no burden of persuasion, under what circumstances, if any, does the imposition of a life without parole sentence amount to an abuse of discretion? Or is there just no, a court cannot abuse its discretion in this particular context. Is that?
No. No, Your Honor. Thank you, Your Honor. The court can certainly abuse its discretion. And under the circumstances, it would be if the court is not considering the mitigating factors, if the court is not considering age the way that Miller requires it, if the court is improperly or inadequately considering a factor. Those are the points that we agree with the defense is if the court fails to consider or improperly or inadequately considers, certainly that would be an abuse of discretion. A court that ignores, certain mitigating factors in exchange, in an effort to seek a life without parole sentence, or conversely, a court that doesn't.
I'm just not sure how that, I don't get how that logically squares. If there's no, why wouldn't you argue a court can't abuse its discretion if there is no burden of persuasion? It's just kind of a moral judgment. It is kind of a black box decision. Why is, my mitigation is your aggravation? How can you say I've abused my discretion in a system where there is no burden of proof?
Well, I think pragmatically it wouldn't be, logical for us to argue or for this court to decide that a court can't abuse its discretion. Certainly a sentencing judge can fail to follow the layout of Miller. I mean, if the court fails to consider factors that they are required to consider in cases involving juvenile lifers because the court, refuses to hear about the age and its hallmark, features, or doesn't care about the defendant's home or family environment, those would be an abuse of discretion because that's what the court says it's required to at least consider when it's presented with the information. The reason that part of the reason that I don't think a prosecutor or the state can't be responsible for presenting or have the burden of proof are the Miller factors preclude the prosecution from accessing information sometimes that's only known to the defense. The way that we have the defendant's home and family environment in this case is because the defense presented the mitigating evidence of it and argued that mitigates the, brings the crime down and all of the other characteristics of the crime and takes it out of the life without parole realm. We argue that obviously that information they presented doesn't mitigate to the extent that they believed it did. A court can abuse its discretion simply by giving one factor more consideration than another where the evidence clearly shows it shouldn't have. So I don't think that by saying neither party needs to actually, prove life without parole is required or disprove it, a court can still abuse its discretion if it just fails to follow the guidance put out by the Supreme Court.
Is it not, are you saying that they abuse discretion when they don't consider them at all? Or, which I think is what you said earlier, that they could abuse their discretion in that regard if they completely ignored a factor or refused to hear a factor. Is it your position that there is still a way that they could abuse their discretion if they do consider them all, but in a way that's incorrect?
Certainly. If a court gives inadequate weight to a factor that the record clearly establishes should be given more weight. Now, again, and this is, I think, where Chief Justice, I understand your question as well, is, at what point do we interfere with the discretion of the sentencing judge to say, no, I think this one deserves more weight? And I think that's just part of the check and balance of our appellate courts. But there are obviously going to be cases where courts can say, I'm going to look at this factor, and even though, the only evidence that I have of the defendant's home and family environment is that, he was in and out of foster care, I'm going to say that weighs completely in favor of life without parole because, for whatever reason. Well, that wouldn't make any sense. I mean, the fact that somebody's in foster care could weigh either way depending on what the other facts are. So if a court gives inadequate consideration to that and simply says, I'm going to give life without parole, who cares about, the family and home environment? I know that kind of goes more with the completely disregarding
Right.
it. But if it gives only, subtle or not enough consideration or doesn't fully consider the information that's provided, maybe looking at one fact and ignoring another where there's no, dispute between the factors. So if you have two factors and the court just simply wants to choose one over another, for whatever reason, that could be an abuse of discretion. And I don't for a minute expect this court to think that I'm saying that this is easy.
Can I ask do you think that there is a difference between, as an appellate court and giving deference to a trial court sentencing decision and the process and the reasoning that they go through, of deferring, and that's why we have an abuse of discretion, say on, an issue like they misscored OV 5. And whether we step in as an appellate court or what our role is there a difference in looking between what the trial court is doing in looking at a pre-sentence report or scoring OV5 and whether or not a sentence is unconstitutional because it violates the defendant's constitutional rights as a juvenile?
Well, I think, so the last portion of your question is what kind of, I had a nice, great answer for you until the last portion of the question, but I think I agree that the court considers whether the judge abuses their discretion the same way as they would do a sentencing guideline or a factor considered by the sentencing guidelines, as they would for determining whether or not the court considered the relevant mitigating circumstances and the evidence that was presented for those. The same way that there needs to be evidence of, to support the scoring of a guideline, there needs to be evidence of a mitigating factor relevant to age for the court to say, well, that weighs, more in favor one way or the other. I think that while it is different, the ultimate answer to your question is that no, that they consider it, whether it's a constitutional argument or not. The sentencing court should still consider it based upon the information that's provided and whether or not that factor has been established by the record evidence. Same way as they would the sentencing guidelines. So for that, I think the answer is yes, they're the same, excuse me.
Counsel, the way that I think about this, and I'm not sure it's right, and that's why I'm asking you this question, is Miller essentially transformed a sentencing decision on the part of the trial court from a non-discretionary sentence to a discretionary sentence. And the judge has presumably never had the opportunity to exercise his or her discretion in the context of a new sentencing. So don't we attempt to put the trial court back to where he or she was at the original sentencing. There's no burden that has to be placed on either side. And we review his decision, his or her decision, like we do any other judicial sentencing decision by abuse of discretion, as you say.
I agree wholeheartedly, 100%. Nothing to add or nothing to subtract from that.
This is replacing a non-discretionary determination with a discretionary determination.
And that's precisely what Miller did. It simply eliminated the lack of discretion and required, in a sense, the court to say, when you're looking at the juvenile, you need to consider age because of the difference.
Would you think that it's an abuse of discretion if the trial court were to say that the defendant didn't produce, I'm finding against or whatever way on a particular factor because the defendant didn't prove to me otherwise?
No, I wouldn't go the extent to say, well, the defendant didn't prove to me otherwise, so I'm going to find against it. I think if the record lacks evidence of a mitigating factor and also contains evidence that support a life without parole sentence, then it's simply the court is not penalizing the defendant for failing to produce something which may not exist. The court is simply looking at the evidence it has before it and saying life without parole is appropriate, absent something that says it's not. That doesn't mean that there is a presumption in either way. It's, you start out just like any other sentence, like Justice McCormick said, Justice Markman said. I would also note, getting away, I guess, from the burden in this case, that the defendant in this case is a textbook example of what the rare, irreparably corrupt juvenile that Miller is considering. And I mean, I don't need to go through the facts of the case with this court, of course, because they speak for themselves. But if this case is not one of those rare cases, then what is? I mean, this case has everything. And the defendant, continues as, time goes on to exhibit all of the same, I guess, characteristics of somebody who is irreparably corrupt. And that's laid out well by the trial court's decision in this case, and also by the Court of Appeals, which followed that. So In this case, it seems clear that this is a good example and groundwork to establish what is a life without parole juvenile. And it's not simply based upon the defendant being 4 months away from turning 18. And with all due respect, one of the issues that I had was with the premise of the second issue here about whether or not the judge properly, considered the defendant's chronological age and its hallmark features, and did not focus on his, rather than focusing on proximity to the bright line age of 18. I don't believe that the trial court focused solely on the proximity to the bright line age of 18. I think that the court evaluated his individual characteristics as Miller requires. And for that reason, this is just not the type of case where the court abuses discretion. And more importantly, I think it needs to be said that individualized sentencing means individualized case factors. It's just not in this case. There is nothing the court did that could amount to an abuse of discretion based upon the facts that were brought out at both the trial, the sentencing, and the defendant's institutional record. So for that reason, I would ask that the court affirm the defendant's sentence.
Counsel,
Sure.
would it always be an abuse of discretion if there were no evidence or no findings of fact that were ascertained by the court in light of the fact that the threshold proposition in these cases is that age is a mitigating factor, more or less, depending upon how close you are to the age 18, I suppose. But given that even in this case, where he was about 17 and a half years old, it's a mitigating factor. Is it an abuse of discretion where there are not some non-mitigating or aggravating factors, however you want to characterize these, that would outweigh that mitigating factor of age?
Well, with all due respect, I'm not sure you could ever not have a mitigating factor with a murder case. I mean, the defendant's been convicted of murder. That itself is an aggravating factor that would be present in every case.
The nature of but that is a consideration too, the nature of the crime, of course.
Absolutely, Your Honor. Yes. So I think this, it's not as if because there's no presence of a mitigating factor that it should be life without parole. That has never been the state's position, nor is it now, that there is a presumption of life without parole. It is a neutral, individualized sentence that just simply must consider all of the relevant surrounding factors. So, and if you have any questions, I'm here and available. Thank you.
Thank you, counsel.
There are a few points that I do want to make in response to the government's argument today and some of the questions of the court. I think first and foremost, we hear abuse of discretion and we think, sure, the judge has discretion, but that doesn't mean it's unreviewable, and that doesn't mean that discretion isn't guided by the law, which is why this court has routinely recognized that an error of law is an abuse of discretion. And so that's where our analysis of the trial court's reasoning does establish an abuse of discretion. The trial court here made multiple legal errors in its analysis of the Miller factors. And the court did consider something other than the proximity of Mr. Masalmani's, to his 18th birthday. It also apparently rested a lot of its analysis about Mr. Masalmani's chronological age on its concerns that 18-year-olds wouldn't receive the benefit of the Miller decision, and decided that that meant this factor weighed in favor of life without parole. That reasoning is totally backwards, and it isn't specific to Mr. Masalmani. And so while she concluded there was no evidence that this factor was mitigating, the record shows that the opposite is true. So that's one example of a legal error.
Wasn't she just articulating herself poorly in this case? This is a very nuanced concept, and I'm not sure all of us are very clear about the kind of balance. At least I'm not very sure that I know how this balance operates. But wasn't she effectively saying that at the age of 17 and a half, I don't think the defendant enjoys as much of a mitigating consideration as he would if he were 17 or 16 or 15?
No, Your Honor, I don't think that's a fair reading of the trial court's opinion. The trial court found that factor actually supported a sentence of life without parole. So that means she found it had no mitigating effect, which cannot legally be true, and also isn't true on this record, which showed that Mr. Masalmani was less mature than the average 17-year-old because of the quite extraordinary number of traumas he had endured throughout his life. Which relates to another mitigating factor. I mean, this notion that there is no burden, especially the burden of persuasion, is novel. It would be novel, and we would expect that if the legislature intended for that to be the case at these proceedings that they've prescribed by statute, they would have expressly stated that, because it's not the status quo. One thing that came up earlier, I think Chief Justice McCormick may have said something along the lines of, my mitigators are his aggravators. That is one of the biggest problems with the trial court's analysis in this case, and part of why the death penalty analogies are not apt. Miller is in some ways like the death penalty in that it requires individualized sentencing. That's not novel in Michigan because we've already had a long-standing practice of individualized sentencing, but in some states it was. But what's different from the death penalty is the death penalty allows states to develop lists of aggravators, mitigators, and for those to be sort of balanced in this great moral judgment made by the sentencer. Miller is different. Miller does not establish a scale. It's a one-way ratchet. These factors can only be considered for their mitigating effect. So when the trial court decides that Mr. Masalmani lacks the capacity for change because his childhood was so horrific, that is treating a factor that is mitigating as a matter of law as an aggravator, and that runs afoul of Miller.
I don't see in the statute where it says that the court shall conduct a hearing and consider the Miller factors and only for mitigation, because the very next clause is, and may consider any other criteria relevant to its decision. So it may be that the list of Miller factors that the judge goes through, that there might be the same facts that that judge is considering as relevant to their decision, and that might be an aggravating factor.
So it is true that the statute does allow for the consideration of some aggravating factors, but it's the Miller decision itself that makes it clear that these factors are to be considered for their mitigating effect, for not how they excuse or justify the homicide, but for how they make a juvenile who has this greater capacity for change less blameworthy than the mature adult who committed the same offense.
So you want a trial judge to go through the Miller factors and make a determination that, yes, the facts lead to mitigation, and make that determination, not go through the Miller factors and say this mitigates or aggravates. That's where you have an issue with.
I mean, that is one issue in this trial court opinion. That's correct. They are not things to be weighed for or against, and that comes from Miller. Mm-hmm. And this court recognized the same in Skinner, where it determined that there was no Sixth Amendment problem specifically because these factors are all mitigators. And so that's why I say a judge runs afoul of Miller when it does treat them as aggravators.
Well, didn't Miller explicitly indicate that it was appropriate for a sentencing court to take into account the differences between juveniles of different ages? So when the court focuses on somebody being 17 and a half as opposed to 14, isn't that what it's doing? It's not saying it's not a mitigating factor. It is saying it's less of a mitigating factor than it might otherwise be.
It's fine for a court to say that I find this mitigating, but not especially so. But I would also remind this court of our U.S. Supreme Court's longstanding authorities in cases like Eddings that establish clear as day that youth, even a youth as old as 16 or 17, for them, chronological age is a mitigating factor of significant effect. And that is something that long predates Miller. And so first of all, to simply go based on his chronological age, in some cases, a judge might risk it not actually being individualized, because not every 17-and-a-half-year-old is the same. Some 17-and-a-half-year-olds are going to be more or less mature than others. And so there needs to be an individualized assessment as well. And here, the court described what the testimony stated, but then said there was no reason to find this factor was mitigating, and she found it aggravating. That was error. The prosecution today has suggested that perhaps the statute only really intended to set up a notice requirement. And I know that's not an argument the court has heard for the first time today. But when the legislature wants to establish a notice requirement, they do. They know how. We see it in things like, I'm going to confuse the numbers because they're very similar to these, but the statutes related to prior CSC and DV bad acts. Also, sometimes, even when it's only a notice requirement, the prosecution still bears a burden, like with 404B evidence, where they have a burden to show that that evidence is being offered for a proper purpose and that it's relevant. So the suggestion that this is just a notice requirement also doesn't explain why the burden of persuasion shouldn't rest with the government.
Can you tell me why there would be a burden of proof in a situation in which the U.S. Supreme Court has said there's no presumption of either a sentence A or a sentence B?
Because the prosecution is seeking a particular sentence that requires a particular constitutional analysis and showing. And so they should, as is the rule across all aspects really of Michigan's jurisprudence, as the party seeking that outcome, they bear the burden of convincing the court they are right. I could see as there was some discussion of the burden of production versus the burden of persuasion. If the court were considering a shifting burden where perhaps the defense did bear some burden of production related to the mitigating factors, I would encourage this court to be very clear that any burden of production would be very minimal. I mean, all it would take to invoke the Miller factors essentially is a birth certificate to establish chronological age. And that would then invoke the Miller factors, and the burden of persuasion would remain, as it does, in Michigan, both in civil and criminal law, with the moving party.
But aren't we asking the prosecutor to prove a negative at that point?
Not necessarily.
If the point of the Miller factors is to show mitigation, and you want a judge to walk through each and every one of those, the prosecutor, I mean, what are you asking them to do? Get up and say the opposite before they even know what the defendant is saying? This is why, you know, under each of these factors, there's mitigation?
Well, no. So the prosecution files its motion, which does have to lay out reasons. And I believe 25, maybe not 25A, also requires the defense to file an answer. So after they do that, the Miller hearing begins. The picture will change. So it's not that the prosecution is charged with proving the negative, but that once all of the evidence has been presented at that Miller hearing, they still carry the burden of persuasion to show that their request for a life without parole sentence has merit. And one other point I do want to emphasize that I don't think we emphasized as well in our brief is this court's decision in Chapa, which it predates Miller, and it really talks about the sort of foundation of our sentencing in this state. We tailor our sentences to the offender and to the offense, and it's because we are trying to balance two very important policy objectives: the protection of society, balanced against maximizing the rehabilitative potential of the offender. And in Chapa, the court expressly stated that while resources allocated for rehabilitation may be inadequate, and some persons question whether rehabilitation can be achieved in the prison setting, this view of sentencing is the present policy of the state. Here, the sentencing court expressed concern that Mr. Masalmani needed more help than the MDOC could offer, while disregarding the significant progress he had already made in his early years in the MDOC. Her concerns that the MDOC's resources may not be adequate are speculative, not supported by the record, and not an appropriate consideration at sentencing under Chapa. And so I would ask the court to really, in its opinion in this case, provide these trial courts with guidance. There is a lack of understanding at times about what mitigation is, about whether or not it has to be related to the offense or somehow explain away the offense, even though the established U.S. Supreme Court authorities say there is no such nexus requirement. When courts lack guidance about this critical issue, arbitrariness is the result. And I think the criminal defense attorney's brief has laid that out far better than I can. But there was a time in this country when the death penalty was briefly determined to be unconstitutional because states were applying procedures that gave courts no guidance, and arbitrariness results. Our system can have no confidence that these sentences are accurate if our trial courts don't have the guidance they desperately need. Burden is one way to help them better understand their decision-making. Clarifying that the Miller factors are only to be applied for their mitigating effect is another way. The criminal defense attorneys of Michigan have suggested additional procedural protections to help ensure that we don't end up in cycles of having endless Miller hearings over and over in cases where courts aren't sure what they're doing. They're doing their best, but they're still not getting it right. And with that in mind, I would ask this court to reverse or to vacate, and specifically to vacate, because what we are not asking this court to do is to overturn the judgment of the lower court, but to recognize that her analysis did not pass muster and to send it back for a new Miller hearing so that she can make that analysis correctly.
You're saying her analysis failed to pass muster on the basis of our abuse of discretion standard, right?
Yes, Your Honor,
Okay.
because of the errors of law she made in her analysis. Thank you.
Thank you, Counselor. The case will be submitted.